Thanks so much, Daphne, for the kind introduction, and it is a pleasure to be spending the next few minutes together with you discussing copyright. So I've prepared some slides which I will start sharing. And in the time at my disposal, I will be focusing indeed on the basic requirements for copyright protection and the rights granted by copyright. But first, let me start by trying to answer the question what copyright is and what it does protect. So the first and most straightforward answer to that is that copyright is the legal shape of creativity. Indeed, the objects protected by this legal right range from books to art, music, films, and so on. So clearly it is inherently connected to creativity. That said, it is also an instrument of technological governance, and indeed modern copyright laws were born in response to a groundbreaking technological innovation of the 1500s. So that was indeed the invention of the printing press. So all of these made it much quicker and cheaper to make copies of books. And so the question of how regulating the production and circulation of these copies became a pressing one to tackle. And that's why copyright is indeed the right to control copying. And just as an additional demonstration that is what copyright has been doing throughout history, this picture of Oscar Wilde was at the center of a US Supreme Court decision in the late 1800s, and the very question was whether photographs could be protected by copyright, on account that at the time photography was a new medium of expression, a new technology, and there were concerns that probably photographs might not be entitled to the same level of legal protection as other types of artistic works, for example, paintings. Eventually, the response of the US Supreme Court was that photographs will be protected by copyright like any other artistic work, and today there is no doubt that this is indeed a classic object of copyright protection. And fast forward to today, indeed, the debates that you might have been reading about concerning artificial intelligence, the production of outputs generated with AI, whether they might be legally protected or not, indeed do echo issues and questions that have animated the copyright throughout its history. So, what I would like to do is break down my presentation into 4 parts. The first one is indeed trying to zoom in a bit more on what copyright is and why it does even exist. Second, what requirements need to be fulfilled for copyright protection to arise. Third, what rights copyright does grant. And the final part will be how to comply with indeed these legal restrictions on the use of materials. So starting with the first issue, what copyright is and why it does even exist. Here I thought of asking indeed Google and specifically Gemini, and this is the AI overview that I got. It is pretty accurate in legal terms. So indeed, we read here that copyright is a legal term that grants creators of original works exclusive right to control how their creations are used. That is indeed correct. So copyright is a property right which is originally given to authors, but it is transferable, and indeed the ownership of copyright can be vested with entities like publishers, like record labels, who are not also authors, and it is indeed a property right that allows to exclusively control how a work is being exploited. So why does this legal right exist? In essence, there have been various justifications given across time and across countries. That said, a main divide can be drawn between countries that have conformed to the French style understanding of copyright and countries that have followed more on the footsteps of the UK and the United States. So the first block of countries, which roughly corresponds to many continental European jurisdictions, have understood the copyright as some sort of natural entitlement of an author. There is a direct connection between an author's personality and their work. An author pours indeed their own creativity into producing a book, producing music, and so on. And because of that, there is a natural entitlement to receive legal protection. Vice versa, Anglo-Saxon jurisdictions such as the UK, the United States have adopted a different logic to justify copyright protection, premised on a public interest view. The works protected by copyright are valuable to society. We all enjoy music, literature, art, and so on. But to keep stimulating the production of these objects, there is the need to afford legal protection to their authors. So copyright is a form of legal incentive that is given to stimulate the production of these works. So this main distinction indeed goes back centuries and still today is relevant because it justifies the different shapes of copyright protection that we are seeing in different countries. So it is not just a theoretical distinction, but it has actually shaped how this legal regime has come into existence and the scope thereof up until this day. Having said that, copyright, unlike other intellectual property rights to which it belongs, indeed the copyright is an intellectual property right, arises automatically. So you don't need to register anything, you don't need to pay anything. The only thing that is required is that you produce a work that satisfies the requirements of legal protection. And if you want to have more details about the copyright, in essence, the key requirement for protection to arise is that there is an author who has produced a work which is sufficiently original. Protection is automatic and extends for a certain period of time, so it is not endless. And at the international level, this minimum term of protection is the life of the author and 50 years after their death. However, if you look at countries like those of the European Union, the UK, the United States, the term here is life plus 70. So it is a rather long term and indeed it is something that has also been progressively extended over time. So copyright protects original works, it does so automatically and it has a duration that in Europe is the life of the author and 70 years after their death. Then the second question is what is required for this protection to arise? This is something that I've already anticipated. And in essence, no matter where you are located, there are three basic requirements that need to be fulfilled. The first one is that there must be a work. And in this sense, it is crucial to understand that copyright does not protect simple ideas, facts, procedures, methods of operation. What it does protect is the expression of these ideas. Example, if I have an idea to write a play about two teenage lovers coming from enemy families, falling in love with each other and then going through a series of events that leads to a tragic destiny, I'm sure that some of you will recognize a plot that is similar to Romeo and Juliet. But something like that is not protected by copyright as such. What is protected is the expression of this idea. So indeed a work is an expression and simple ideas are not protected as such. They are free for anyone to use, at least under copyright law. The second requirement is that there must be an author, someone who has created the work. The third one is that the work in question is sufficiently original. Then, depending on the countries, you might have additional requirements that you see on the slide, but I will not go into the details of them at this time. What I would like instead to do is to offer a quick focus on the requirements of author and the requirements of originality. So let's start with what an author is. And I think that this French case is quite helpful to understand what we are speaking about. So you may be familiar with contemporary artist Maurizio Cattelan. He's one indeed of the best known artists these days for his provocative works and so on. But the interesting thing is that he has not materially created all of his works. And indeed, like many other artists, he has availed himself of the help of craftsmen and indeed workshops that will be realizing the work for him. One example is La Nona Ora, this sculpture representing Pope Karol Wojtyla, which was realized indeed by the artisan that you see on the right-hand side, Messier Drouet. And in essence, Messier Drouet materially made the work. He tried to obtain a declaration from a court that he will be the author of this work and not Maurizio Cattelan, but eventually he lost. Why? Because it was demonstrated that what Messier Drouet had done was simply to execute the instructions of Maurizio Cattelan, but did not provide any creative input himself. So in essence, to be an author, you need to be the person in charge of the creative process. And this discussion has been made even more acute and, if you wish, also interesting in the current AI age. How far can you push things using AI tools and still be an author in a legal sense? And this is a question that many authorities and offices have been concerned with. One example is the US Copyright Office. And in a nutshell, the response is that you can use AI, still be an author in a legal sense, but you must have the control over what the AI does and therefore remain an author in a legal sense. The second focus I would like to offer is the one on originality. So, copyright is not premised on novelty. A work does not need to be new, it needs to be original. What does that mean? That the author must exercise free and creative choices. Both of them are needed. And that is a legal standard that I would say is broadly established across most countries around the world. Simple effort is not enough. Freedom and creativity are both required. So, for example, if you take a digitized image of a painting, like the one that you see on the slide, a claim that a museum will be owning a copyright over this digitized image is questionable, because it is doubtful that both freedom and creativity have been exercised in realizing a digitized image that sought to be as close as possible to the original painting. There must be a distance, an expression of creativity, otherwise copyright does not arise. So, a claim that this will be copyright protected is indeed something that is legally questionable. Then we come to the third point. What rights copyright protection does grant? Here it is key to understand one thing, that is that copyright is not a single right, it is a bundle of rights, and they belong to two main families, moral and economic rights. Moral rights are personal rights of the author, and they are meant to safeguard the personal connection between an author and their work. And here we go back to what I was discussing a few minutes ago. That is indeed that in some jurisdictions there is a strong emphasis on the personal connection between an author and their work, and that is why moral rights are legally protected. Different countries recognize different rights, but on a minimum international level, you have two key moral rights. The right to be credited as the author of a work, that is known as right of attribution, or in some more dated text, right of paternity, but it could be also a maternity right at this point. So I would say more correctly, it is called the right of attribution. And the second is the right of integrity, that is the right to prevent any distortion, mutilation of a work that is prejudicial to the honor or reputation of the author. I will return on this in a moment. Then we have economic rights. Economic rights are transferable, so you can sell your copyright so that these rights belong to someone other than the author, and relate to the possibility of exploiting economically a work. There are several rights. Most of them have been harmonized at the international and European Union level, meaning that the level of protection that you would have in a country like Germany is in essence the same as you would have in Spain, Italy, Greece, Portugal, so all the 27 EU member states. And then, of course, there are also exceptions to economic rights. These are activities that fall within the scope of protection of copyright, and yet they can be undertaken by someone without needing permission. An example for all, if you include in your educational materials an extract from a poem, from a novel, for the benefit of your students, and you comply with the legal requirements, and this extract is justified by the educational purpose that you are trying to achieve, then you may not need a permission from the copyright owner. But again, it depends on the circumstances. In law, and perhaps in copyright law, the answer, it depends, is always the right one. So let's focus a bit more on moral rights and economic rights. Moral rights, as I mentioned, serve to safeguard the personal connection between an author and their work, and they are non-transferable, so they always remain with the author. And the truth of the matter is that these rights are quite different from country to country. There are countries like France, Italy, in which moral rights receive strong legal protection, and countries like the UK, the United States, in which the protection is much less than in these continental European experiences. Let me provide an example from France, just to let you understand what an example of a moral rights claim can be like. So the one that you see on this slide is a famous case concerning the unauthorized colorization of a black and white movie, Asphalt Jungle, by director John Huston. It was a movie featuring Marilyn Monroe as the lead actress, and it was released in black and white. Subsequently, it was colorized without the director's permission, and the director was not happy about that, and he brought a legal action in France claiming that this unauthorized colorization of the movie would be an infringement of his moral right of integrity. In the end, the French Supreme Court did agree with the director and found that this unauthorized activity was a breach of his moral right of integrity. So this is an example of a situation in which someone is not happy with how their work is being used by others, and they can legally prevent this activity. Coming to economic rights, there are several of them. Of course, the most basic one is the right to control copies made of one's work, and that is technically known as right of reproduction. Then there is the right to control sales and other distribution of one's work, and that is known as right of distribution. There is a right to control the rental or lending of works. For example, libraries to operate, they need a license from the relevant copyright owners, that is, book publishers and the likes. If you want, similarly, to perform a play in public, you will need to obtain the permission of the owner of the copyright in the play for you to be able to do that. And that is known as public performance. Same thing, if you post on the internet someone's book, you will need to obtain permission from the copyright owner. That will be an act of reproduction because you will be making a copy of the book, but also communication to the public because you will be giving access to that copy. And then if you want to turn a play into a film, that also requires authorization because it will be an issue of adaptation. And copyright also grants authors and copyright owners the right to control adaptations of their work. So changing the medium of the work, making a translation, doing a sequel, and so on. So in essence, all these rights that you see on the slide belong to the owner of the copyright, who is entitled to carry out these activities on their own or by authorizing others to do that. So in essence, copyright, as I said, is a property right, and you are in charge of deciding who can do what in relation to your work. However, not always permission is needed. Indeed, there are instances in which you don't need this permission, and the reason for that is because copyright protection needs to be balanced against other fundamental rights and interests, as it might be the right to express one's opinions, the right to exercise creative freedom, and so on. So, for example, if you want to quote a short extract from someone's work, or if you want to criticize someone's work, in principle, you may be able to do that without the need for an authorization, because what the law does protect is your free speech. Same thing if you want to make a parody of someone's painting, someone's song, etc. In many countries, not necessarily all, but in many countries, you may be legally entitled to do that by relying on an exception for parody. And this leads me to the final point that I would like to make, that is how to comply with copyright laws. So, as I mentioned, first of all, it depends on who the owner of the relevant rights is. As I said, moral rights are always with the author, but economic rights can be transferred to others. So the owner of the copyright may be the author, but may also be someone else. And indeed, there are situations in which it is more likely than not that someone else is the owner of the copyright. Example, if in Europe you create a work in the course of your employment, either by operation of law or because of your employment contract, your employer will be the owner of the copyright in your work and not you as an employee. Then, of course, there is the issue of how to exploit the rights granted by copyright. And this can be done through different contractual instruments. Two main ones are worth mentioning. The first one is licenses. That is a contract by which you give a permission to carry out an act that is legally restricted by copyright. And the second one is an assignment or transfer by which you sell your copyright to someone else. So the effects are very different because with a license, you remain the owner of the copyright, but with a transfer, you give away your copyright to someone else. And then, as I mentioned, there are situations in which no permission is needed because an exception is applicable, but that will depend on the circumstances as well as what law does apply. And with that, I've reached the end of the time at my disposal. If there are any questions, also in the chat, I'm happy to take them or leave them also to later on. You are very welcome to contact me by email. Thank you very much.
Thank you very much, Eleonora. Thank you. Does anyone have any questions before we move on with the second part? You can, of course, feel free. Yes, we have a question from Konstantinos Panagiotou. Works for hire applies only to US or the EU as well?
The answer is that this is a doctrine that is typically American, so you don't have an exact equivalent in Europe, but in essence, you can achieve the same practical result by using other ways. But a work for hire doctrine is typically an American legal concept.
Thank you. Thank you very much. you can either raise your hand or feel free to drop your questions in the chat as well. Okay, let's continue with the second expert. Thank you very much, Eleonora. Okay, we will continue with Anthi, Ms. Anthi Akritidou, Head of Legal and EU Affairs and the International Federation of Reproduction Rights Organizations. Welcome, Anthi. The floor is yours.
Hello, thank you so much. Hi, everyone. Let me just try to share my screen, please. Okay, give me a second, as for some reason it doesn't work properly for me. I believe you can now see my screen, right?
Right, we can see your screen.
Okay,
perfect.
Excellent. Thank you so much. Hello, everyone. I'm very pleased to be here today. I would like to thank Daphne and the organization of this event, the rest of the organizers as well. So before delving into my presentation, and I think Eleonora actually gave an excellent overview of the regulatory framework, I would like to introduce the organization I work for. This is EUIPO, the International Federation of Reproduction Rights Organizations. This is an independent non-profit membership association. It is based in Brussels. So what do we do exactly? We facilitate on an international basis the collective management of reproduction and other rights in text and image-based works through our members, the cooperation of our members, the so-called collective management organizations or reproduction rights organizations. So what do we mean by saying collective management organizations? These are entities that manage or administer, let's say, copyright and other related rights on behalf of their members, typically authors, publishers, performers, or producers, and so on. And when it comes to the collective management organizations in the text and image-based work sector, these are also referred as reproduction rights organizations. So this is why we have EUIPO, the RRO corresponds to reproduction rights organizations. Nearly all RROs are members of EUIPO. We have 130 RROs as members, and in total 160 members, as we also have author and publisher organizations. Our members represent many millions of authors, visual artists, publishers of books, journals, newspapers, magazines, and printed music. And as I mentioned already, Eleonora provided an excellent overview of the framework, of the regulatory framework, and I will now build a little bit on that by beginning my presentation with some general context, and I will offer some insights on how the creative sector sees copyright. Many of the elements I have included here have been already pointed out by Eleonora, so the next few slides could also work as a recap, kind of. So let's begin with a very simple question. Why do we need copyright? Copyright is a legal right which is granted to authors to protect the original works of authorship. So these works can be literary, artistic, and so on. Copyright is a branch of intellectual property rights, and it gives to creators the control over their works, how they want to use them, whether they want them to be reproduced, shared, performed, and so on. But copyright does more than just protect. It also empowers. It recognizes and rewards creativity. And thanks to copyright, creators can choose to license their works and earn revenue from it without having the constant fear of the work being used in an unauthorized way. So there are two main components of copyright, as Eleonora pointed out already. First, the economic rights, which allow the authors and right holders to earn money from the use of their works, and the moral rights, which preserve the personal connection between the author and their creation. This is, for example, the right to be credited or to object to derogatory treatment of your work. And now you might wonder, okay, but why do we need copyright? Why don't we just have and allow free use of creative works? That would make things simpler, right? Well, here is a fun fact. First of all, creators do want their work to reach as many people as possible, right? They want their works to be broadcasted, shared, reproduced to the broadest audience possible. But without proper payment, it becomes nearly impossible for authors, publishers, and other rights holders to keep producing new content. So if there is no incentive, no reward, the motivation to keep creating would disappear. And copyright ensures that creators can sustain their work and continue contributing to cultural and creative industries and sectors. So it's not just about protection, it's about promoting ongoing innovation and expression. Let's now take a closer look to what it actually protects. We already heard about that, so this can be, as I mentioned, a short summary. Copyright protects any original work, any original intellectual creation in the literary, artistic, scientific fields, as long as it is expressed in some form. For example, we have written or spoken text, musical composition, plays, choreographies, and so on. I have included some more examples on my slide. And there is an important distinction we should keep in mind. So, as noted before, copyright does not protect ideas, it does not protect information or theories or principles themselves. It protects the way that all of these have been expressed, so the expression of those ideas. Also, for a work to qualify for copyright, it has to reflect the author's own intellectual creation, so there must be an originality that carries a personal touch. Eleonora already mentioned that copyright does not need registration, and this is, I think, often something that surprises people because we know that some other intellectual property rights with which you are probably familiar, like trademarks or patents, need registration. So as soon as a work is created and fixed in a form, whether it's written down, recorded, or published, it is automatically protected by copyright. And besides copyright, which belongs to authors, we have some other similar rights which protect publishers, producers, artists, and so on, the so-called related or neighboring rights. These rights extend protection to these people who help bring those creative works to the public. Even if their contributions do not qualify as original, copyrighted work, then we grant them this set, let's say, of rights, because these individuals and organizations often invest time, skill, and resources in order to bring a work to the audience. These are copyright-like rights, the right to control reproduction, for example, to communicate their work to the public, to distribute it, and so on. And these rights ensure that their works, their contributions basically are fairly recognized and rewarded. Now, let's talk about how works can be used. In general, if you want to use a copyrighted work, you must get permission from the author or the right holder. Using a work without this permission might be considered copyright infringement, and that can lead to legal consequences. So when can a work be used freely? My colleagues later will elaborate on this, but in short, there are two main situations. First, if the work is already in the public domain, it means that its protection has expired or it was never actually protected. We're talking about very old works. And second, if the use falls under a clearly defined exception or limitation for certain educational research purposes or commentary purposes. And here's a few key principles to remember. Always assume you need a license unless it's explicitly stated otherwise. Some exceptions do allow limited use without permission, but these are strictly defined by law and only apply in specific situations. And ultimately, these rules, so the exceptions and limitations, are designed to balance the rights of creators with the public interest in order for the creativity and access to knowledge to both thrive. So when in doubt, check the rights. And why does access to creative content matter, especially in education? Many of you today that participate to this webinar come from the educational sector. So you know that access to a variety of teaching material is essential. Diverse content helps to enrich this learning experience. It makes it more engaging, inclusive, and effective. And teachers and educators often rely on resources from all kinds of sources, like books, academic journals, websites, videos, music, and so on. But here we have the legal side. Again, if the material is protected by copyright and your use is not covered by an exception, you will generally need a license to reuse it. Now, while there are these exceptions, especially for the educational sector, let's say, these are not always clear-cut, which means that you are not always sure whether they apply or not. In fact, across the EU, exceptions are not fully harmonized, and they are usually interpreted narrowly. That means that the same activity might be legal in one country, but not in another one. And that's why licensing remains the safest and most reliable route. It offers legal certainty and ensures that content creators are fairly compensated, supporting a sustainable creative ecosystem. So what are some common educational uses that usually require license? For example, displaying a film, a movie, a video in a class, photocopying pages or extracts from textbooks, distributing sheet music to students. So licensing supports both the rights of creators and the needs of educators. We have mentioned licenses a few times by now, but what exactly is a license? A license is basically a legal agreement between the copyright owner and the user. It spells out exactly how, where, and for how long a copyrighted work can be used. In other words, it defines the terms and conditions for using a creative work, and it ensures that the use is both authorized and respectful of the creator's rights. Licensing is important because it lets creators retain control over their works, while it still allows for others, educators, students, businesses, for example, to use it legally. There are two main types of licensing. We have direct licenses. This is when permission is granted straight from the author or the right holder. It's often tailored to a specific use case like a school play, a research publication, or a podcast. And we have collective licensing, which is managed by collective management organizations, as we mentioned before, or RROs. They handle rights on behalf of multiple creators, and they offer blanket licenses. This makes it more easy for institutions like schools, universities, and business to access a wide range of content without negotiating individual agreements for each work, because otherwise you would need to go to completely different rights holders and ask for permission, which, as we can understand, is a bit time-consuming. Here I have created a scheme which basically shows what I told you before. We have the creation of an original work, and provided that the use of this work is being done through a license, this leads to some revenues for the authors, for the rights holders, and then it leads back, it operates, let's say, as an investment in new creative content. As I just mentioned, getting licenses directly from individual rights holders can be really time consuming and often impractical. So that's especially true for schools and universities that need access to a wide range of materials quickly and efficiently. And this is where RROs come in. RROs operate across different legal systems, and they offer a flexible, efficient, and reliable solution for educational institutions. They ensure legal certainty, especially when it comes to digital use or cross-border learning environments, which are becoming, of course, more and more common. So what do they do exactly? RROs administer rights on behalf of authors and publishers, particularly, as I mentioned in the text, an image-based sector, books, articles, and other educational materials. This is especially important when a rights holder does not want to manage the rights themselves, or when it would be too difficult or impossible to do so. Every year, RROs collect license fees from users like schools, universities, and then they distribute them back to authors and publishers, helping to support the continued creation of high-quality educational content. And another fun fact, RROs started appearing in the 70s and 80s. They were actually set up in response to requests from educational institutions which want to copy parts of published works, which were legally published, of course, but they didn't want to buy the entire book or journal. So now let's take a closer look at how licensing works in practice, especially in the educational sector. Licenses are not just one size fits all. They are usually negotiated between RROs and organizations that represent the educational community. This can be, of course, the Ministry of Education of a specific country or other federations or networks of schools and universities. So there are networks that represent different universities, and they conclude these licenses. The goal is to make sure the license terms actually reflect the real needs of education and learners. So licensing agreements are tailored to different factors, including the educational level. Of course, there are different needs within the primary, secondary, or higher education. The teaching methods, which are being used from traditional classroom instruction to digital learning environments, and the tools and technologies that schools are using today. These licenses cover a wide range of uses like scanning, photocopying, printing, using content in digital platforms or virtual learning environments, display of materials during classroom teaching, and so on. And importantly, these licenses evolve as technology and education also change. They are designed to stay relevant and effective in today's quite fast-paced learning environments. Also, the coverage is quite broad. A single license can apply to teachers, staff, students, and therefore it makes it easier for institutions to stay legally compliant without overcomplicating things. So at the end of the day, licensing in education isn't just about legal compliance, it's about enabling access and supporting innovation in teaching. Here I have included a scheme which can also be found on our website. The slides will be shared with you, so I will not stay that much here. I will jump into my next one, which gives some of the specifics for the different collective licensing approaches. There are different legal systems and rights management choices, and all these have led actually to a variety of licensing models, which are used by RROs, and they are often applied individually or in combination. Depending, of course, on the country, there are different systems like voluntary collective licensing. Here, RROs license use of works on behalf of rights holders who have opted in, so who have chosen actually to proceed in this way. Voluntary licensing with legal support we have extended collective licensing. This can be mainly found in the Nordic countries, where also rights holders that have not opted in are covered, and the revenues will actually go back to them as well, unless they have explicitly opted out. We have mandatory collective management, where the licenses are voluntary, but as long as a rights holder wishes to continue with licensing, this can only actually be done through the RROs, so not individual direct licensing. And we have some non-voluntary statutory licenses. These are granted by law. We don't need to inquire the confirmation and approval of the rights holders, but they will still receive, of course, compensation from the RRO. For example, in Switzerland, there is such a system for some uses. Collective licenses can include rights to use both national and international works. This is made possible because authors and publishers give mandates to RROs, who then enter into bilateral agreements with other RROs worldwide. So from the licenses perspective, usually ministries of education or representative bodies, these negotiations happen at an institutional or governmental level. And now you might ask, okay, but how much of the work can be copied under these licenses? The answer still depends on the country. Typically, copying limits range from 5 to 20% of the work under licensing agreements, but there is some flexibility, especially if the work is no longer for sale, available for sale. In many cases, most RROs allow copying of a full chapter of a book, even if that exceeds the usual percentage limit. And when it comes to the fees and how the fees are actually set, this depends on factors like price per page copied or price per student by the license, covered by the license, or sometimes we are talking about a lump sum agreement for an entire institution or region. And of course, these licenses and the fees are tailored to local contexts and are based on actual usage data. And this is my very last slide with some key takeaways to wrap it up. So first, have always in mind that in principle, you generally need authorization to use copyrighted materials in order to support your teaching and learning. There are exceptions to copyright law, yes, but these exceptions are often unclear and limited in scope. Many of them contain vague language and require further legal interpretation. Plus, these exceptions are not harmonized across the EU, meaning the rules can differ depending on the country. So, what should you do to stay on the safe side? First, check with your educational institution to find out if any licensing agreements are already in place. Then maybe they have you covered. And second, visit your national RRO's website for detailed guidance and information about licensing options. All RROs, at least within Europe, have a website, and they have a specific section which is dedicated to licenses for educational uses. Following these steps helps you respect copyright, ensure legal use of the materials, and support the creators behind them. Thank you so much, and I'm available, of course, for any questions.
Thank you very much, Anthi, for this enlightening presentation. Would anyone like to ask a question at this point? Okay. We can move forward with Bartolomeo Meletti, Senior Lecturer, Head of Knowledge Exchange Create at the University of Glasgow, who will provide us with valuable perspectives in understanding Creative Commons and open access resources, as well as the use of AI in education. Welcome, Bart.
Yeah, thanks, Daphne. Just to say there is one question that just came for Anthi. I don't know if you want to take that. Yeah.
Is the display of publicly available videos such as YouTube in class charged?
So basically, as an action, in order to do that, you need a license unless in the specific country we are talking about, it is covered by an exception, because the exceptions are provided by the EU law, but it depends on how they have been transposed in a specific country. So in principle, you need to have a license, as I mentioned, unless it falls under an exception. But to the extent that you need this license, most of the RROs, most of the organizations providing for licenses for educational purposes also cover the display of videos in the classroom.
Thank you. Thank you very much, Anthi. We have another question for Croatia. So in Croatia, business as usual. If it is justified, you can use somebody's work for educational purposes. I don't know if this question is addressed to Anthi Akritidou or to Eleonora. Would you like? Would you like?
I cannot see the question. Can you please repeat it, Daphne? Because
in Croatia, business as usual. If it is justified, you can use somebody's work for educational purposes.
I think it's more like a comment.
Okay.
When it comes to Croatia. Sorry, I could not see it. That's why I was a little bit confused, but thank you.
Okay. Thank you. Thank you very much. Okay, if there is any other question, we can move forward with Bartolomeo. The floor is yours.
Thanks very much, Daphne. And good morning, everyone. Kari and I, so the next speaker and I sort of reshuffled a bit the topic. So I won't be covering AI. I'm covering duration, exceptions, and open licensing primarily. So I think Kari will talk about AI later, just to clarify that. Generally what I'm going to focus on is a sort of a zoom in to some of the things that have already been mentioned, mainly by Eleonora, but also by Anthi, which are some of the opportunities that EU law offers you to lawfully copying existing materials, because one way, of course, to use existing materials is with permission, especially when works are protected. But then, we've heard about justifications of copyright and different systems in different countries, and basically under any of those systems, copyright is limited in time and scope. And so those from a user perspective, who can be an educator, for example, in this case, those are opportunities for lawful copying. And so the way I'm going to do that is, I think, as you probably realized already, copyright can be quite complicated. So on the right-hand side here of the screen, that's a screenshot from, the European Commission page on EU copyright legislation. You can see there are like 15 different directives to consider, a number of international conventions, and all the Court of Justice cases. And I'm not saying that to scare you or overwhelm you, but in a positive spirit, to say that in light of that, I'll try to make these as practical and as accessible as possible. And in that spirit, I'll be using a resource called copyrightuser.eu, funded by the European Commission through the Horizon 2020 consortium, Recreating Europe. So that's a website which is publicly available that kind of translates all of those directives and conventions into accessible guidance. And so as you see, most of my slides have links, use graphics and illustrations from that website, and also have links. So I'm very happy to share the slides afterwards, so you can go and deepen your knowledge of each of the topics I'll be mentioning. And again, I'll just be, I got like 20, 25 minutes, so I'll be giving an overview of these topics. There's only so much we can cover, but I'll try to do, in a way that is as practical as possible. As I also point you to actual resources where you can find teaching materials and so on. So the 4 opportunities for lawful copying I like to focus on are the idea-expression dichotomy, very briefly, just to give some shape to that principle that Eleonora and also Anthi mentioned. Then I focus a bit more on copyright duration, mention some of the challenges of using out-of-copyright works. So again, as you know, the previous speak copyright lasts for a certain period of time. After that, you can use the materials, which becomes free of copyright. Then I'll look at open licenses, in particular Creative Commons licenses, and I'll use that as a way to introduce you to some resources that are available out there for you to reuse materials for teaching purposes and other purposes. And then I'll end on copyright exceptions. Again, as a way of introduction, I'll focus on one exception in particular, which is for teaching purposes. But again, don't feel like you have to take notes all the time. The slides will be shared, and you'll have access to everything I talk about. So the idea expression dichotomy, as it's already been mentioned, copyright does not protect ideas themselves, only the way in which ideas are expressed, in a medium like books or artistic works and so on. And under the same principle, it doesn't protect facts, information, theories, and so on. And here, again, it's a principle that may sound theoretical, but is actually, very much practical and has got practical implications, even in the commercial space. So, for example, the example you see here on this slide is an example of how, big companies also can rely on the idea expression dichotomy for successful initiatives. So in this case, the idea is the battle royale story. So the story where you have like a bunch of people fighting against each other. And, basically the same story is being borrowed and reused and repurposed by a lot of very successful initiatives, both in the film industry, but also the TV industry and the video game industry. But, the same principle applies to educators, of course. So if you see a nice idea that you like to teach something, you're free to borrow that. So that, for example, one of the resources I'll show you later is the Europeana Classroom, where you can find a bunch of open educational resources, learning scenarios. I mean, in that case, as we'll see, you can use the whole thing because it's distributed under an open license. But even if it wasn't distributed under an open license, like the underpinning idea, the teaching methods are there free for you to borrow and adapt to your own purposes. So that's the idea expression dichotomy in a nutshell. Duration, so we've heard about duration. Again, it can be complicated, although it has the nice sort of rule-like nature. So, you have rules under the duration, which is not true under most of copyright provisions, which is like, okay, copyright lasts for the life of the author plus 70 years. After that, copyright expires and you can use the work for free. Then the term of copyright changes depending on the type of work, and also the way in which the term is calculated also changes. So what we've heard so far is the typical rule for literary, dramatic, musical, and artistic works. So in that case, in the EU, like in the UK, and now also in the US, the term is life of the author plus 70 years. Then for films, is also calculated in reference to the life of the author, but in that case, you have to consider the life and death of 4 different people, like the director, the author of the screenplay, the author of the dialogue, and the composer of the music. So if all of those authors have died, and the last to died more than 70 years ago, then the film will be in the public domain, which from a practical point of view means that very few films are actually in the public domain under the current term. There are some old silent films, like Georges Méliès's films, are in the public domain in most countries, but more recent films are not, unlike old paintings, books, and so on. And a very similar rule also applies to works of joint authorship more generally. So a work of joint authorship, for example, is a song that includes music and lyrics. So from a copyright perspective, those are 2 separate works. One is a musical work, the other one is a literary work. And if the 2 were created, for the purpose of creating one song, then that's considered a work of co-authorship. And as such, both elements, both the lyrics and the music, will expire 70 years after the death of the last to die of the joint authors. Then for other types of works, the life of the author doesn't matter in terms of duration. So that's, for example, the case for anonymous and pseudonymous works. For those kind of works is 70 years after the work is made available to the public. However, if during those 70 years the author's identity is revealed, then the normal life plus 70 applies. Again, I realize, it can be quite a lot of information, but all of that is, made accessible on copyrightuser.eu. And then for other types of works that have also been mentioned, which are protected by related rights more than by copyright itself. So like rights on sound recordings, for example, or performers' rights or rights on broadcasts, those are protected for 50 years from the date in which the recording was made, or more commonly, if during those initial 50 years the recording is published, then it's 70 years after publication. And we'll get back to why, that's important, especially when reusing music. And finally, just one that's also been mentioned, moral rights, and I believe Kari will touch upon that later as well. But moral rights also have their own duration, and unlike economic rights, moral rights are not harmonized at the EU level. So they're not subject to EU legislation. They are harmonized to a certain extent at the international level. So basically, to find out, how long moral rights last, you need to check the law of your own country, and that will change in most countries. Either they last as long as economic rights, so they expire together with economic rights 70 years after the death of the author, or in some countries like France and Italy, as Eleonora mentioned earlier, it can be perpetual. Protection can be perpetual because it's justified by those personality theories that Eleonora mentioned. So, to sum up on duration and the challenges but also opportunities that it offers. So basically, once copyright has expired under one of those terms I just summarized, then the work becomes free for everyone to reuse. So all the paintings you're seeing on this slide, for example, are out of copyright, so you can freely include them in your educational resources. However, there are some warnings to be aware of. One, again, which has been mentioned already, is the territoriality of copyright law. So, copyright is different from country to country, and that's true also for copyright duration. Again, the good thing about the European Union is that since the early 2000s, there has been a process of harmonization. So one result of that process of harmonization is that, for example, duration within the EU is largely harmonized. But then outside of the EU, the term can be different. As I said, in the UK is the same, also because those directives were implemented, the duration directive were implemented when the UK was still part of the European Union. But in the US, for example, now the current term is also life of the author plus 70 years, but then, you have other rules as well. And yeah, I mean, again, I don't want this to become overwhelming, but, the duration can get very complicated because it has changed over time, like since the Berne Convention established like a minimum term of life plus 50 years, then it's been extended on a territorial level, and each extension came with transitional provisions. And in the US, for example, there used to be a registration system for copyright works, that if you didn't register your work, then you wouldn't get protected. So that created a sort of a patchwork of laws that, they're a bit hard to figure out. But again, the positive thing is that in the vast majority of countries, very old paintings like most you see on these slides, in this slide are out of copyright, they're free to use. But I would say, for example, like American Gothic by Grant Wood. I think Grant Wood died in the early 1940s. So that specific painting may be protected in Mexico, for example, where I think there is a life of plus 100 years term. So territoriality is something to consider. There are also some other interferences with the public domain from other areas of the law. Again, we could talk about it forever, but just to give you one example, are cultural heritage laws of certain countries, like Italy has got a code of cultural heritage and landscape. And which actually under which the Ministry of Culture, or I can't remember whether the Uffizi Gallery in Florence, did start a legal action based on one of these paintings, the Botticelli's Venus. So basically, like, there are other laws that are not copyright laws that may give other form of control over these, works, if they can be considered national cultural heritage. So again, that's something to be generally aware of, but as an educator, I wouldn't worry too much about it. Like in the example I just gave, for example, the Cultural Heritage Act in Italy provides a specific exception for education, so it does protect cultural heritage materials and also their digital reproduction, but that protection doesn't extend to education, so you can still use it for education. And then what's probably the trickier part of the public domain are the different layers of protection, which again, we've heard about already, but I think like the typical example of that is music, once again. So with music, you've got, the musical composition is one layer of protection. Perhaps there are some lyrics, which is another layer of protection. But then on top of that, if it's something that is performed by a third party, there may be performers' rights. And if that performance is recorded, then the sound recording is also protected. So you have all those like 3 or 4 different layers of protection on the same work. So what does that mean in practice? That, even if a Beethoven's or Mozart composition, the composition itself is out of copyright, if you find a sound recording made in the 1980s of that composition, that will still be protected, like the recording and the performance of that composition. So while you're free to perform the composition yourself, make your own recording of it, like reusing a specific recording published less than 70 years ago, will still require permission. And then, as Eleonora hinted to, there has been for many years also a discussion around whether photographs like those you're seeing on this slide constitute another layer of protection. So all these paintings are in the public domain under Life plus 70 rule, but what about the photograph itself? Is that a new original work that attracts copyright protection? And on that question, and that moves us to the solutions, the European Commission, the European Union did introduce a legislative instrument to clarify the situation, which basically is the 2019 directive, whose Article 14 says that a photographic reproduction of a work of visual art that is in the public domain is also in the public domain. It doesn't attract related rights, and unless it's original. In that case, it is protected by copyright, which again, it could be debated extensively, but at least it clarifies, for example, that provisions that, like in Italy again, used to exist about protecting non-original photographs, those don't apply to works, to the digitized scan of out-of-copyright works. And another more sort of non-legislative solution to that issue is open licensing. So basically, one way to reuse out-of-copyright works. So for example, like all these photographs actually are from Wikimedia Commons, where you can find this digital reproduction distributed under a Creative Commons license. So in that case, I don't have to worry about, okay, is that original, is not original? So the author of that photograph, at least in theory, released that photograph in the public domain. He decided, okay, I'm fine with that, you can use it under certain conditions. And so that's Creative Commons, basically. So Creative Commons are licenses, are open licenses in the sense that they are licenses that allow everyone to use the work in certain ways. And so there are 6 types of Creative Commons licenses, all of which are different combinations of the 4 conditions you can see on the left-hand side here. So all Creative Commons licenses will require attribution, will require to credit the author of the work. Some require to share alike, which means that you can still use the work as you wish, or under the other conditions of the license, but under the condition of then sharing whatever you are creating with that work under the same license. So in principle, if you are creating an open educational resource and you embed, images and other works in that resource that are distributed under a share alike Creative Commons license, then your own open educational resource should be released under the same Creative Commons share-alike license. And then some have more restrictive conditions, which are non-commercial, so you can't use the work for commercial purposes, and no derivative, which means that's probably the most restrictive one. It means that you can't change the work. You only can use the work as it is. And finally, there is another tool, which is not technically a license, but it's the CC0 tool, which is a public domain dedication. So basically, you release the work into the public domain. And you kind of waive your moral right to be attributed, to be credited, but that only works in few jurisdictions where moral rights can actually be waived. So that tool is not entirely compatible with jurisdictions where moral rights can't be waived, like Italy, France, or Brazil. So the equivalent there would be a CC BY license, basically. Okay, so I'm conscious of time. I wanted to give you some practical example of sources of free-to-use material. So there are quite a lot of platforms out there where you can find works distributed under open licenses like Creative Commons. I just focus briefly on two which are funded by the European Commission. So in addition to Wikimedia Commons, which I already mentioned, Europeana is a great one for teachers. So it offers you access to over 60 million items, digitized items. And the good thing, one of the good things about it is that you can search for something, and then you can filter your search by, can I use this? Maybe, yes, with conditions, yes. And then if you click on yes, you find images like this one, where you can then see which Creative Commons license they use. So in this case is CC BY SA, meaning you can use it for free for any purposes. You can modify it under the condition of crediting the author of the photograph, and then to share alike whatever you create with it. And then with Europeana, also the Europeana Classroom, as I already mentioned, is a great resource where you can find full-on open educational resources and learning scenarios. So again, if you don't know that yet, I would really recommend you to explore it. The other one I wanted to mention is the EU Screen initiative, also partly funded by the European Commission, and that focuses on audiovisual materials. So those are basically national broadcasters that make available part of their archives through this portal for educational purposes. So anything you can find there can be freely displayed and screened in the class. And some of those materials, then if you click on a certain item, you can find the copyright status. So most of them are in copyright, so you can only display them, but a few of them are also under Creative Commons licenses, like this one. And then you can contact the provider. There is a form that you can use to contact the archive that holds the material, to get a copy of the material if it's under Creative Commons, or if it's in copyright, to get a license, to get permission directly from the provider. And yeah, all of this basically is also summarized in a little FAQs resource I produced with the Europeana Classroom team some time ago, where you can find a lot of the links I just mentioned in an FAQs format. And yes, and then the last topic I wanted to mention are copyright exceptions, which have been mentioned already. So copyright exceptions are basically cases where you can use protected materials without having to get permission from the copyright owner. And the reason why these uses are permitted, well, are varied, but are basically for public interest reasons, where, like, for either freedom of expression, or for teaching and research, or for personal autonomy, like if a person with disabilities, for example, needs access to the work. There are exceptions that allow that access. And there are also cultural heritage justifications. So there are exceptions that allow, for example, a museum to copy something in their collection for preservation purposes. So one of the problems with exceptions is that, well, they are a bit, their scope can be uncertain, and also is the territorial differences, right? So, as with everything with copyright law, each country has got their own provisions, including about exceptions. So one example of that is, in the US, you have fair use, for example, which is a doctrine that is a bit more enabling, maybe is more, is an open-ended exception that you can rely on also for like technological uses, for example. We don't have that in the EU. We have a list of exceptions, of specific exceptions linked to specific purposes. But, again, the European Union over the last 20 years has been working on harmonizing exceptions. So the first attempt was back in 2001 with the Information Society Directive, which provided only one mandatory exception, again, for technological purposes, that was mandatory in the sense that all member states had to implement it, and then a number of like 20 different optional exceptions that member states could decide whether to implement or not. But more recently, with the 2019 directive, the European Commission introduced mandatory exceptions also for teaching. So there is this new exception that all member states have to implement one way or another. And so that's the text of the law. Again, it's an exception that is supposed to enable cross-border teaching activities. So the whole purpose of this exception is that it's mandatory, meaning that all member states have to implement it, meaning that, if you benefit from it in one member state, in theory, you should be able to use, rely on the exception also for digital uses within the European Union. And you can do that for the purpose of illustration for teaching, as to the extent justified by the non-commercial purpose, so that only allows non-commercial teaching activities. And also it only applies if suitable licenses don't exist. So again, that can change from country to country. If there is an educational license that covers that kind of use, then that takes priority. And also member states can decide to provide for fair compensation mechanisms. If they, when they introduce this exception, they can also say, okay, we have this exception, but we'll collect money this way to then pay the authors. And the one thing I also wanted to highlight is that this exception, like the other mandatory exceptions introduced by the 2019 directive, are can't be overridden by contract. So the Article 7 says that any contractual provision contrary to these exceptions can't be enforced. So that's, again, we can discuss it later if you're interested in that aspect, but that has an effect on whether you can rely on services and platforms whose terms and conditions may prohibit the educational use of their materials. This provision in theory says, that those are unenforceable, if they conflict with you relying on the exception. Anyway, the level of implementation, I'm not sure, so this is a resource, copyrightexceptions.eu, that monitors how the level of harmonization and implementation of exception. From what I can see from that map, it doesn't look like it's been, broadly implemented yet, but that may well be due to just the resource not being up to date. I'm not sure. I think Kari will show you a more up-to-date resource on that from the EUIPO. And so, yeah, that was everything I wanted to say. And the last slide that you will receive lists basically all the resources I've been using through this presentation. Yeah, thank you.
Thank you very much, Bart. We have one question, which I think more or less we have responded. Do Creative Commons licenses apply to software?
Well, that's a very good question. To be honest, I'm not entirely sure. Possibly they can, although I think that Creative Commons licenses were inspired by open software licenses, like the general public license. So the concept of share alike, for example, I mentioned, actually the original concept comes from open licensing in software. So I don't know, maybe technically you can apply a Creative Commons license to software, but basically the software has got their own set of open licenses. So I think open source software, usually they don't use Creative Commons licenses, they use the general license, general public license, GPL licenses. So there is a separate set of open licenses for software.
Thank you very much. We can continue. There is one question, I think. Is the non-commercial purpose of the Article 5 exception excluding it for
private
private universities?
Well, that's another very good question. I think the answer probably changes depending on the jurisdiction. So I can, because I'm based in the UK, so my area of expertise is primarily UK law, but we do have the same sort of question in the UK about other exception, not this specific one, but we have a very similar exception that was implemented under the previous directive, which is also limited to non-commercial purposes. And under UK law, the answer to that is no, so it doesn't exclude any private but also for-profit organization. So under UK law, what matters is whether the use itself is commercial, whether the use itself is aimed at generating income. But so the traditional example is if a student already signed up, pay their fees and they're attending a university course, you can rely on the exception to show them things justified by educational purposes. What you can't do is to use, under educational exceptions, like materials in a promotional video, for example, that clearly aims at generating an income through student fees. But the status of the institution under UK law doesn't really matter in a commercial versus non-commercial analysis. But again, that I can tell that with any authority also only in relation to the UK. EU member states may be different.
Thank you very much.
Thank you.
If there is any other question, we can move forward with the presentation of Kari Kivinen, who is education outreach expert at EUIPO, and who will deepen our understanding in copyright exceptions for educators and copyright duration and public domain. Welcome, Kari.
Good afternoon, everybody. Can you see my screen? Because I've lost it in my...
Yes, we can.
All right. So I will speak to you from the teacher's perspective. I've been working in different European schools for 30 years, and I'm promoting a positive approach to intellectual property and copyright from that perspective. So as you can see in my presentation, I have the Creative Commons sign here. So this is, I've been told that I'm not in the right mode. So I think it's now better. So you can see here that you can use my presentation and but not for the commercial purposes, by attributing that it comes from me. So let's start. So in European Union Intellectual Property Office, we have this positive project, Intellectual Property in Education, where we promote creativity, innovation, entrepreneurship, and responsible digital engagement among young Europeans. And to share with you a fact which is not known often, is that actually intellectual property is very important for our well-being and wealth in Europe. It generates 47% of the GDP, creates 30% of the employment, and it's about 75% of the trade inside of the EU and even more in our export. We have this interactive map where you can I'm so sorry, my telephone is ringing. You can click your country and see what is the situation. And if we are speaking about copyright intensive sector, it's about 70 million jobs in the EU, and it creates only 7% of the EU's GDP. The downside is that there is young generation. We have made studies in our observatory on this, and about 40% of the European youngsters have bought fake products. And what links to the copyright is that about 20% of the youngsters have admitted that they are intentionally downloading illegal sources and using illegal digital content. This is something we should all work for. Now, let's say from the teacher's point of view, I've been meeting teachers for the last 10 years on IP issues. And I've asked that, do you know your intellectual property rights in your institution or organization? And the answer very often is actually not. So few words about it. Teachers are creators. We are creating a lot of materials, lesson plans, PowerPoints. We do all kind of content for our lessons. And we are kind of under the copyright protection. In some, actually in most of the situations, our employer, the school provider with whom we have a contract, are stating that the works created during the work time and in the work are actually belonging to the employer. And what is happening then? Let's see. When this is a statistics about what kind of resources teachers use in their lessons, and it's a proof. The sample is nearly over 8,000 teachers in UK last year, and 56% create and write their own plans and own resources. So just, I'm not repeating what has already been said, but the creator, I mean this time teacher, if you are creating something, you have the paternity right, droit d'auteur in French, to the things you have been creating. Nobody can take it away. You have also moral right, we have heard about it, for your work. What is sometimes what you don't have, it's the economic right. And like it was said, it's normally 70 years after your death. So your grandchildren will enjoy of your creativity if they are selling the licenses of your creations afterwards. And there are these exceptions we have heard about. The copyright exception for teaching, it was described earlier as a harmonized approach in the Europe, which is actually not so harmonized because each country has been adapting and interpreting the law a little bit differently. But what is clear that in no conditions the materials which are used, digital materials which teachers are using, they are not meant for non-commercial, they are meant for non-commercial purposes. They should be used within the education establishment. And based on the discussion I heard before, I would say that the private universities are in the education establishment definition. And there should be a proper citation of the source. So we have created in EUIPO these frequently asked questions on copyright for teachers and students, where you can check, first of all, which are the local authorities and local sources of information in different countries. And then we have 15 questions, but with sub-questions, it's nearly 30 questions where we are answering with the experts to the main questions. And you can click once again your country, and you can get it in your mother tongue or in in English. You can also check what is the situation in different countries, because everything is in English. So if there is this copyright exception, how much teacher can copy and use digital materials in the lessons? And once again, like it was said, that there is a variation between the countries. I have here the exception pédagogique, which is a French exception. 20% of the musical work can be used for education presentation. The full use of visual artworks, paintings, photographs is permitted, and maximum 5 pages from the book which can be reproduced. But you can check from the frequently asked questions on where to find more information in your country. In Europe, the European Commission has a digital education action plan, and there is also these digital competence frameworks. And it's important to notice that intellectual property competencies are part of the basic skills for every citizen. It's not only for teachers or students, but everybody. These are defined in the DIGCOMP 2.2, and actually it's to be updated, and in the end of the year, the DIGCOMP 3.0 will be published. And the digital competence is quite a large area of all kind of competencies. And it involves also digital content creation, which is integrating work created by other ones, adapting them, copyrights, licenses, and also programming. And if you want to read more, you can find it from the DIGCOMP. I have chosen some examples. So the competencies are always defined by knowledge, skills, and attitudes. And DIGCOMP 2.2 are defining that everybody should be able to know that digital content might be protected under intellectual property. Everybody should be aware that creation of digital content is considered protected by copyright as soon as it is created or expressed. It has to be visible or seeable or hearable somehow. That there are also exceptions, and especially for education, and that there are different types of licensing possibilities and also open source materials. What are the skills linked to this? That we should be able to identify and select digital content legally. We should be aware how to use and share digital content legally, what kind of limitations or possibilities there are. And also we should be able to identify which content is falling under the scope of copyright exception. And without forgetting the attitudes, the kind of, in our project, we are promoting this respectful rights for ownership. And it's something, if one feels that I have created things, we can maybe better respect other one's creations. And also that when we are creating new materials, we should be open to check what is available in the open licenses or license schemes, which are making our production even better and more beautiful. At this moment, there is a kind of guidelines for teachers in process in the European Commission. It's called Guidelines for Digital Education Content, and I have a pleasure to be part of the expert group. So we aim to propose a quality criteria and key consideration to facilitate the adoption of the use of digital education content. And it also includes copyright and licensing awareness. The guidelines will be published end of this year, and I warmly recommend they will be translated to all the EU languages, and I warmly recommend you to look for it when it's coming out. So when we are looking at teachers' use of digital materials, there are several moments where kind of copyright issues are coming in game. So when we are looking for high quality digital education material, we have a lot of sources. We have these commercial products, we have materials provided by the school provider. We have also materials in the internet, like it has mentioned, YouTube or other sources. And when we are selecting, we should be taking account also that we have a right to use the material we are selecting in the classroom with our pupils. Then there is this assessing and adapting. There are, for example, Creative Commons. Some of the regulations are not allowing anybody to adapt the materials. So we should be carefully looking of what kind of adaptation we are making to which materials. And of course, when we are sharing the pupils, we should respect the copyright rights. And then, of course, we should evaluate the quality and the impact. In another study, teachers, 70% of the teachers are using next year the same materials they have used the year before. So once you have found a good material, it can be used in the next year. We have already heard the Creative Commons licenses, and we have created infographics for the teachers to help them to choose, to explain a little bit these mystical letters, what does they mean, and you can download it for free and maybe put in the somewhere in the classroom. There is a completely new area of copyright-related issues linked to the generative AI. And in EUIPO Observatory, we have been looking at it very closely. And there are mainly two big issues. The first one is the input. So the generative AI large language models have been trained with a lot of materials which have been taken from all kinds of sources, but they are black boxes. At this moment, we don't have any documentation or transparency on which materials have been used to train these large language models. The big companies are admitting that they have used copyright-protected materials without permission, and it has created several law cases which are happening at this moment. And we are following very closely on how they are going to influence on the laws in Europe and globally. Under the new EU legislation, the AI systems must comply with EU copyright laws, and they are entering in force, for example, AI Act completely next year, summer. And the companies should provide summaries of the content used, but it's not yet clear how is this going to be made. And for teachers, this is something we should avoid feeding AI tools with copyright-protected materials. The basic mistake teachers do is that they take a book which is copyright-protected, they put it as a scan to the generative AI tool as a prompt, and it will be then used by the by the generative AI system for training the large language model. The other issues are linked to the outputs. At this moment, work generated by AI tools with limited or no human input cannot be protected by copyright. For example, this picture on the right, it's created by AI tool. Anybody can use it, and it can be copied and used without any limitation because it doesn't have a copyright protection. Another problem is that sometimes the generative AI tools are creating outputs which are very close to the authentic products. And that's why there are a lot of, once again, lawsuits going on, which we are following. For teachers in EUIPO, we have created in several languages. At this moment, we have English, French, and German in our Ideas-powered website, where you can get an interactive infographics on how to use generative AI in education from the copyright point of view. I warmly recommend it. It's quite fun resource. The tips for the teachers from the copyright point of view is that, first of all, you should use AI tools which are properly licensed by your institution. It's normally the task of the school providers to propose tools for that. And then, once again, do not feed copyright-protected content or any confidential content in the generative AI tools, because it might create problems afterwards. And when you are using copyright AI-created stuff, like I'm using this picture here on the right, one should clearly label, like we refer to the other sources. It's a transparent way of sharing copyright materials. OECD, European Commission, and American Code.org has published a draft AI literacy framework a few weeks ago. It's now under comment. Please, if you are interested in this, it includes also copyright-related competencies and questions. It's an interesting approach. We have also created in materials for students and teachers on IP. We have created this MOOC, and for example, if you are interested in going further in the copyright, you can do the copyright model in our Academy Learning Portal. You have to sign in and then go for the module. You will get a certification that you have done a copyright module proposed by European Union Intellectual Property Office. I warmly recommend it. Just last comments is that for teachers who are creating digital content, check the copyright rules for educators in your country, in your region. And when you are using text or images or audio, video, which you haven't done yourself, check how they are protected. And if they are protected, you can either buy a license or use the content in the public domain, like Europeana, which was proposed a few minutes ago, and give the proper attribution to the author. Or what is the option, which is, I recommend it, create your materials yourself and take care that it's attributed to you. If you want to learn more about the IP, copyrights, and education, we have this ideas-powered teaching materials available in most of the European languages. We have also the resources which you can download for free, and you're welcome. Happy to answer to your questions. Thank you.
Thank you very much, Kari. I don't know if there is any, does anyone have any questions? We have a lot of links sent from Tina Filzek from EUIPO. Thank you very much for the information shared.
Maybe we have tired our listeners by providing so much information in a so short time. But the message I would like to share is that we are all creators and we should be proud of it. And we should value our own productions better than we do at this moment.
Yeah, and just say I completely agree with that positive attitude, really. Like it's in a way, you know, the copyright user projects. I mean, the copyright user started in the UK as the UK website, then it was extended to the EU. Start from that premise, really like to communicate, you know, copyright in a positive way, because, you know, especially in the digital age, we're all creators, we're all faced with, you know, copyright questions, and you know it is a positive thing that promotes, you know, creativity and education, among other things.
Indeed, we have one question. Who is responsible of ensuring actually that AI tools used in the classroom are properly licensed?
I can answer to this.
Yes, please.
So in the AI Act, Article 4, it kind of clarifies the responsibilities. According to this Act, the providers, I mean the employers, in this case school providers, should be, first of all, check that all the employers, in this case teachers, have sufficient AI literacy. And this AI literacy, one can discuss it, what it means, but it also includes this copyright issues and licensing issues. And it goes without doubt that also these school providers should give guidelines for the teachers on how to use AI in the school institution, what kind of recommendations there are and they should also choose which tools can be used. This has created in some countries, for example, in Finland, which I know well, that Helsinki, which is our main region for capital, for time being, they have forbidden teachers to use AI tools in the classroom because they are defining how to use AI tools in a safe way in education, starting from early education in Finland, primary and secondary education. So my answer would be here that it's the task of the school provider. Training AI literacy for the users and to be guidelines for the teachers how to use and also which tools are safe to use.
And if I may jump in here, I would also like to mention that there have been already launched some AI licenses, let's say. So use of the AI basically for internal purposes at this point by some RROs, some collective management organizations, in order to ensure that these AI tools will be used responsibly, ethically within specific, basically business sector. But I believe that educational institutions can somehow be covered by that because this is only for internal purposes. So, for example, if you need to make a summary of something and you need to present it within the specific organization, the business sector and educational institution, then yes, it's not for training AI per se. So some very popular LLMs like ChatGPT and so, it is limited to this kind of conditions. And I will be happy to share maybe a link to our website, which includes all these organizations that have already launched this kind of models.
And yeah, just to add that, I mean, at least at university level, it also depends on the kind of contract the university has with the AI provider. So at the University of Glasgow where I work, we have a contract with Microsoft, for Office and all the software they provide, and that contract also includes Copilot, which is the generative AI tool, and that contract comes with conditions and. So that at least at the university level, whoever signs the contracts will also sign contracts with those providers that usually have copyright clauses.
And maybe behind the scenes note, since we had a discussion already with the rest, of course, of the speakers, we thought, and Daphne can confirm that in order to tackle the AI issue and all the nuances of it, which are so many, of course, a different series of webinars would be needed because there are so many things and it is quite new. I mean, not AI per se, but generative AI as technology. And there are so many issues, probably more questions than answers at this point, I would say.
Yeah, I completely agree with that. And I think that educators are an incredibly important voice in that debate, really, because, I mean, of course, the use of generative AI is, incredibly potentially disruptive for education. And what does that mean, for assessment, for, like skills and, how do you keep critical thinking? But, I think through that broader discussion, I think educators can can meaningfully participate in the copyright and AI debate as well, because it applies at so many levels, really, from teachers to students and what students also produce. And I think, these kind of broad debates shouldn't be addressed in isolation, really.
Thank you. Thank you very much. Thank you all for attending today's session. If you have any feedback or questions, of course, feel free to communicate to me these questions, and we will be more than happy to answer them very shortly. Please do not forget also to check the follow-up materials that we will be sending to you shortly as well. Thank you all for attending. Your participation and insights were truly valuable. We appreciate your time and look forward to seeing you in our future sessions. Thank you all.
Bye.
Yeah, thank you for inviting me. Nice to
Bye-bye.
participate.
Bye.
Bye.
Thank you.
Bye-bye.
Bye bye.